Thank you all for being here. We are at the greatest San Diego Association of Realtors. There is my name, there is my telephone number, and again, there is my email address. That'll become important to us later. We are recording, I believe, Jane, we are recording, right? Yes, we are. Okay, good. All right, now, so here are some credentials. Again, this is just the sign of a bored mind that just needed a little more entertaining. So I have a lot going on there. I don't recommend necessarily that you all do all that. Certainly, if you're going to go to law school, you might want to talk to me first. I can probably talk you out of that, but I'm often asked the question whether I would do it again. I don't really know. I don't know. It was a lot of work, but it was worth it. So anyway, that being said, we are going to be talking about subjects that are going to appear to be legal. I am not a practicing attorney. I really have no interest in it at all, but I do a lot of trial work, usually testifying on behalf of brokers regarding issues of standard of care and market conditions in San Diego, which of course is not a hot topic at all right now. So moving forward, our conversation is not intended to be a substitute for the advice of your broker, nor for that of your attorney. So we recommend that you do seek their advice. You're paying them to be there, so I would recommend that you talk to them and consult with them as appropriate. Okay. All right, so we're going to talk today about member benefits, and among the many member benefits provided to you by SDAR is, of course, education, and I'm proud to be on the education committee, serving with Linda, and I know we have quite a few people here today that are also on education, and so anyway, I'm thankful that I'm Rocky. Hi there. Thankful that I have the opportunity to work with them in that perspective. It is actually a department, not just a committee. So it's a pretty, it's one of the biggest things that we have to offer you as members of our association. So today, we're going to talk about home fire hardening, disclosure, and advisory. And I'm often asked questions about things that most people would think would be very boring, but I'm going to tell you that I'm going to spice this one up for you quite a bit. There's a lot to cover when we're talking about home fire hardening. It is a law. It did take effect at the first of this year. Let me see if I have it in here. So it did take effect at the first of this year, but it was retroactive back to properties built prior to 2010. So we're going to cover a little bit of that. We're calling it the home fire hardening disclosure and advisory. So at first, what are those things? And so those are going to be a requirement to have building resistant materials and home features that protect a home from catching fire. So while there is, CAL FIRE, we're going to talk a little bit about CAL FIRE during this presentation today. They would really like us to fix those things that are possibly could cause a building to burn. If you've lived in San Diego for any period of time, and I've been through a couple of really good fires here, if you can call them good fires, 2013 in October, 2017 in October, they were fires that did a lot of damage and hurt a lot of structures, hurt people, livestock, things like that. And so we are very concerned that we are not fueling those fires. Are we doing things that are going to enhance those fires' ability to spread and become even bigger than they normally are? So we're going to talk about some of those things today. And I'm specifically going to show you the forms, the form that we have for that purpose. But this has two prongs to it. One of them is, and people ask me, well, if my property doesn't apply, we're going to look at what application it has, but does it hurt to make the disclosure? And the answer is it never hurts. If it doesn't apply to your property, and again, it's a disclosure if it does. If it doesn't apply to your property, then it is hi, Daniel. It is, thank you. It is this is the home fire hardening right on your screen, home fire hardening disclosure and advisory. So that's what we're going to be talking about. Thank you, Daniel. Folks, Daniel brings up a good point. Please take a look. If you have a question, I would normally like to open it up to where you were able to chat with me online, loud by voice, but we have so many people here that it's going to prohibit us from being able to do that. I am excited about the fact that the association is starting to open back up again. I think tomorrow is a big day in California for us to start working our way back into having live presentations, and there's nothing I would like more than to be in front of you or actually following you. I always think of myself as being a follower rather than the leader, but anyway, and doing my presentations in person. So back to where we were. If you have a question, the Q&A button down there is a really good one. Just wherever it is on your screen, just talk about. If you have a question, just go ahead and put it in there. Commercial leases, business rentals. Daniel, we'll probably talk about that a little bit later, not today. Hopefully it wasn't on the calendar for today because I've got home fire hardening, disclosure and advisory. So again, it never hurts to disclose. That's critically important to remember. But if the disclosure isn't required for the particular property, there's never any harm for also providing the form, because it just becomes an advisory. Okay, so again, I don't think there's a harm. We have it in our template in our company so that when we do a real estate transaction, it's either going to apply or it doesn't. We're still going to provide it. It's still going to be a disclosure if it applies. If it doesn't apply, then it's going to be an advisory. And I'm going to show you some of the ways that you can find out whether or not it applies. But we're going to talk about that in a minute, and we're going to talk about your liability as well, and that's important. So when does it apply? When does the home fire hardening disclosure and advisory apply? And the answer is it applies to the following. We're going to have 4 different scenarios, much like we have in the Home Equity Sales Act. We have a residential 1 to 4. So obviously, single family home, a duplex, triplex, fourplex, condos, manufactured housing, it's going to apply. Okay, so in those scenarios, so all of my residential 1 to 4s that were constructed prior to January the 1st, 2010. I guess the assumption is that since that time, the building materials and the construction requirements are such that we're making materials that aren't as quick about burning, but we're going to talk about defensible space and stuff like that. So anyway, constructed prior to January of 2010. So let's just say 2009 and back. Okay, so now all of a sudden we have some more critical dates to keep in our mind. I know when you got your real estate license, you were told you were told 1960 was my earthquake retrofit requirement disclosures. 1978 is my lead-based paint requirement disclosures. 1978, pre-1978 housing, whether it has lead-based paint or not, we must make the disclosure that the possible existence of lead-based paints. And now we add to that another date here, and that is going to be the home fire hardening disclosure. Okay, so number 3, if located within either high or very high fire hazard severity zone. Okay, so if it is located in one of those zones, so I've got my residential 1 to 4s, I've got my, you can go back, constructed prior to 2010, and then I have whether it's located in one of these 2 zones, and you're going to ask, how do I know if it's in one of these 2 zones? And I'm going to give you a heads up here in just a second. But the 4th thing is if the seller is required to provide a completed TDS. So the same standard TDS exemptions apply, which means, certain bank-owned property, again, has to be the foreclosing bank, not just any bank that owns a property. Okay, as long as they only own paper, they don't own the property, they don't exercise dominion and control, which was a Supreme Court holding on the subject many decades ago. Actually, back when I was getting my graduate degree, we studied that. But if the bank exercises dominion and control, then they have to, disclose. So, for example, collect rents, things like that. So those are my 4 prongs. Let's put them all on one page. So I've got residential 1 to 4s. I've got constructed prior to January of 2010, located in either a high or very high fire hazard severity zone. and if the seller is required to provide a completed TDS. If the seller is not required to provide a completed TDS, then they don't. Then this requirement is also not there. Another date. Thank you, Daniel. That's an interesting point. Okay, so asbestos disclosure for rentals built before 1981. Okay, so that being said, those are our 4 elements that are going to trigger the requirement to make the disclosure. Now, one of the things that I would like to do right now is I would like to pull up my, this is what we refer to as the recitals. So again, you can see, oops, I forgot to log in over here, sorry. What we refer to as the recitals. So this is the heading of the form. I can probably show you really quick the entire form. So here is the entire form, the home fire hardening disclosure and advisory. And again, folks, please make sure you're using the current version. And this was put together in December of this past year. And okay, so I think we're good. I don't have any feedback. Okay, so I have another computer going so I can actually see what you see. So I'm sure I'm on the same page. So anyway, make sure you're using the current form. We're going to talk about this top part up here, but we're going to go through this line by line. You are going to understand this better than anybody when we're done here today. Okay, so let's go ahead and break it into its component parts. We're going to start off with, again, what we refer to as the recitals, which is the linking part of the document that links it to other parts of our transaction. So this is the disclosure and advisory to the purchase agreement normally, or maybe some other document. Now, as we're about to discover, it is only required in certain leases. Daniel raised a good question about asbestos, but we're going to talk about when does this disclosure requirement apply to a lease, and we're talking about that in just a second. So I've got my date field, I've got my property addresses, I've got my buyer, and I've got my seller. Okay, so let's take a look, about these disclosures. Let's break this down. I want to go back to my PowerPoint really quick because it is required on leases, but it's only required if it is with an option to purchase the property. And as most of us know, we used to call that creative financing. I've done many a talk on creative financing. An option to purchase is very different than an option, than a lease option is very different than a lease purchase, those kinds of things. We stopped doing those in the early 80s. I know I was doing them and everybody was doing them. And then we started getting more lawyers. And so we just realized we need to pass that off to council. Let them do it. If I have a ground lease coupled with an improvement, then I would be required to also do that lease, okay, or do that disclosure. Okay. So what are my sources of information? Well, probably the biggest one that I have is going to be my natural hazard disclosure report. It could also be the natural hazard disclosure company, but that's usually a big clue as to whether or not the property falls in one of those zones. I have never met a seller that knew whether or not their property fell in a certain zone. Frankly, I've never met a seller that knew what a zone was. So when you get your natural hazard disclosure report, it will tell the seller whether or not their property is located in one of those zones as identified by the state of California. Okay, and again, we know those as 2 fire, 2 earthquake, 2 flood. Okay, so and then we also have governmental sources where that information should have been filed. Okay, so let's go ahead and let's take a look at that paragraph. I've labeled the paragraphs here so that in case you want a copy of these later, I can always give those to you. So here's my original as to only required for sellers of residential properties with 1 to 4s constructed before January 2010. Again, this is the very first paragraph in the document itself. Located in either a high or very high, 2 zones, fire hazard severity zone, either, not both, either, if the seller is required to complete our TDS. Okay, and then where can I find that information? Possible to locate it by consulting with your NHD company or reviewing incumbents information. Also, maybe available through the local agency where the information is supposed to be. And I'm going to show you some of those sources here in just a second. Okay, so let me pull up my diagnostic here again. CAL FIRE has created a fire hazard severity zone viewer. And so here is the link to that website. You just click on this little guy right here, and it takes you to that website. Now I do well, of course, and then I clicked on it, and of course now it's going to pull up that website, which is great because the slide I had I didn't think was going to do it much justice. But can you all see that? Let me see. Nope, you cannot see that. So let me pull this up. I think this is pretty interesting stuff. So again, this is our FHSZ viewer. Here is the website. This is the link to get there. And you can see that this is a fairly complicated issue. Okay. So for example, if I'm looking over here, I'm looking at whether or not I'm in a very high fire hazard severity zone or just a high fire hazard severity zone. So you can see it blankets most of the state. All right. In some places it's moderate, but you can clearly see from down in here, and I'm going to move my map up just a little bit. So the benefit of doing a live presentation is that I can actually zone in on this for you. And you can see that San Diego County is quite well within a lot of the zone. Here's my very high fire hazard severity zone. And so, and folks, I live in such a zone. Yes, I definitely live in such a zone. And I think a lot of us do. This is a pretty large area for it to cover. So if you want, I can give you these links later, and happy to share those with you. But you need to be very, very, very aware of that zone. Now, I'm going to tell you, like anything else, and we're going to hit it again as part of the presentation, but like anything else, I would not probably go to the zone. I would probably not go there. I probably wouldn't comment on it. I would probably recommend to your client that they go there, and that recommendation is actually done within the disclosure itself. Okay. All right. So again, that link is in the disclosure. Oh, there's my map of it. Okay, I did a pretty good job. I guess I honed that down in there. Agents may provide the link, but we are going to recommend that you do not check the maps, nor do you draw the conclusions based upon the maps. So just like everything else, the seller's filling out the TDS. You are not allowed to fill out the TDS. It needs to be the seller's disclosure. In my trial work, frequently the question comes up as to whether or not the seller filled it out. Now we've made it, even whether you're using Glide or Zip forms, we pretty much made it where you've got to go out of your way. You've got to circumvent the program to fill out those documents for the seller. And again, we advise that you not do that, and you definitely do not, it's not a defense. When the seller is sitting up there and asked by opposing counsel or even their own attorney probably, whether or not they filled out the disclosure, and they say, no, the agent filled it out for me, that's not going to probably go well. It's probably not going to make its trial, actually, probably settle. You're not allowed to fill those things out. So same kind of thing happens. You should not be checking the maps. You should not be drawing conclusions. You should just tell the seller, well, I'm looking at the NHD, and on that NHD, it says right here that you're in that zone. So do you want to check the box or not check the box? And I'm going to show you the appropriate part on that. But the point I do want to make is that it's very similar to Megan's Law. So we have a requirement by law in California that we disclose the existence of a database. Okay, so the Megan's Law is a good example. The home fire hardening is a good example. There is a database. We just tell people about the database. We don't go to the database to see whether or not somebody is on the database or whether or not the property is in the zone or anything like that, much like you would not go down to the county and pull permits for your client. That's up to your client to do that. And frankly, it's something that they're concerned about, okay? But frankly, we have permit pulling agencies out there that will do that work for you and save you a lot of that liability. And obviously they have their own insurance to cover them in the event that they make a mistake. But as it comes up in the legal system, at least for me, you are held to the standard of the education required to get your real estate license, and how to go through these databases and how good you're on computers and all that kind of stuff. So frankly, I've never been to the Megan's Law database. All right, so because if I go to the Megan's Law database, then I'm going to be held to have constructive knowledge of everything on the database. And in this case, everything in the terms of the home fire hardening disclosure and advisory, every property that was in there. So I'm just not going to go to that. I'm just not going to add that to my arsenal, my issues that I'm going to have to deal with. So let's talk about some of the other requirements that you're going to have. So the home is or is not in a high or very high fire hazard severity zone. So this is the box for the seller to check. And so a lot of us will get that form up in front of us and we'll look at it. We'll go, well, I have no idea. Remember that the requirement is on the seller, not on you. And the requirement is for what the seller knew or should have known. So the standard of care for the seller is that they knew or they didn't know. I was involved in a transaction recently. Seller says, I don't know. They didn't have access to the natural hazard report yet. And so they didn't check the box. Well, during the course of the transaction, the other agent said, hey, wait a minute. It's, we got the natural hazard disclosure. It shows that it is in the zone. The seller needs to amend their disclosure. And frankly, there was nothing to amend because the seller had not checked the box. So the property was in the zone. In fact, it was very close to an area that common sense would tell you is probably going to run the risk. Because remember, those flying embers can go a mile away and start a fire on a house. And so, if you're anywhere near that type of vegetation, then you need to be, you need to, at least I would make the advisory. Okay, that's the point I'm trying to make. So in this case here, the home is, or if checked, it is not. So the default language says it's in the zone. Okay. And again, if you tell somebody that it's in the zone and it's not in the zone, then you're much less at risk than if you tell somebody that it is not in the zone and in fact it is in the zone. Because much like my natural hazard disclosure cases, the only remedy really for the property being misidentified to be not in the zone is to you can't move the property out of the zone, so probably the cost of the home. Okay, so we have a question. Hey, Rocky, that's why you should, Rocky, 10 points right there. You get A+. This is why you should order the NHD as soon as you take the listing. That is, I should have put that in here in bold print. That is exactly, you and I are thinking alike, and I'm going to pull that up in just a minute because I did put it in my presentation that you need to be ordering all of these disclosures. You need to be pulling up all of your statutory disclosures. I think all of your disclosures need to happen at the time of the listing. Okay, and Rocky's point's a really good one. Remember, just like the TDS, if I send all of the disclosures over with the counter offer, so prior to the buyer committing to the offer, then the buyer has no 3-day right of rescission. But if this one shows up late, they can cancel, they can rescind the contract. Remember, rescission rights go to statute, and cancellation rights go to contract. And so rescission rights, very powerful word of law. Put the parties back where they were before the contract, make it all go away, everybody gets their money back, bye, you're done. Okay, so even if the property is not in either of the zones specified above, or if the seller is unable to determine whether it is, if it's in one of these areas, and I want to call this common sense, right? Any of these kinds of areas with flammable materials, seller may choose to still make the disclosures. There's no harm in making the disclosure. And again, if it doesn't apply to the property, then it is simply an advisory. And again, as I said earlier, it is in our template. We're going to provide that in all of our transactions. Okay, seller may voluntarily make the disclosures, even if not mandated by law. Okay, all right. Let me pull on my PowerPoint again. So what are those disclosures? We're going to talk about removing combustible landscaping within 5 feet of the home, replacing wood or shingle roofs, decks and patio covers should be made of fire-resistant materials. Walls should be made of resistant material, not boards or shingles. Eaves should be non-combustible. Install dual pane tempered glass windows. Chimney outlet metal screened. Fix loose or missing bird stop eaves or closure. Okay, so let me go back to my little chart here really quick because I think I'm already moving into this is my number 2, which is my notice. Notice that it is in bold print. Okay, and remember that the law says that it needed, if it's going to be the same size font as the rest of the document, then it needs to be in red. But since we understand that you are not that we believe you may not have a color printer, then the law says that if not red, then in 10-point bold font. Okay, and this is 10-point bold font. Home is located in a very high fire hazard severity zone, was built before the implementation of the wildfire urban interface building codes, which help to fire harden a home. To better protect your home from wildfire, you might need to consider improvements, information on fire hardening, including current building standards and information on minimum annual vegetation management standards to protect homes from wildfires can be obtained on the internet. And there is the website. And let's take a look at that. Let's see if I can find that website in here. We did that already. Actually, you know what? Because we have that. Nope, I can't print and pull on that one there. So hang on a second for me. Here are the home fire hardening things that we just talked about. And again, let me pull that up. I would like to have that in front of you so you can see what that one looks like. I don't know where I put it. Gosh darn it. In there someplace. Okay, I actually have that one in there as well. So I'm not going to pull that one up from right now. But I do have that readyforwildfire.org, and I'm going to show you what that looks like in just a minute. But home fire hardening features. Now be aware, seller is aware of the following features that may make the home vulnerable for wildfires. So people call me up and they say, do I check the box if it applies, or do I check the box if it doesn't apply? Well, it says right here that you know that this feature is going to make the property vulnerable. So if you don't know, the standard of care for you, again, is knew or should have known. And if you didn't know, you had no reason to know, then this will probably be completely blank. Okay, I don't think, though, that it harms you to check the boxes. And I've already read you some of these that I had the list all made up. The eaves, the soffit. Does anybody here know what a soffit is? Roof ventilation, where the attics have, or where the vents have openings in excess of 1/8 of an inch. This is from the statute, folks. So this is important language. Okay, ember resistant. You know, that stuff, we always see it on the news, right? The embers flying all over the place, creating all kinds of problems. Roof coverings made of untreated wood shingles or shakes. You know, we stopped building shake roofs a long time ago. You know, I've got personal knowledge of whole communities that have lost, you know, in Scripps Ranch, for example, where the whole community lost their home because of those types of roofs. Okay, they're very popular back during a certain building time. Combustible land state, you know, anything within 5 feet of the home and under the footprint of any attached deck, you know, that's just asking for trouble. So again, rain gutters without metal or non-combustible gutter covers, those kinds of things. We're going to talk about home. I don't want to talk about that just yet. Let me take you back to our PowerPoint. So this was the list. These are all the little things that we've got to tell them about. Again, my home fire hardening disclosure is part of Civil Code 1102. Okay, and you all know, you've heard me say this before. California Civil Code 1102. I got my TDS in there. Right, my NHD is going to be in 1103.7, but my TDS and all that and the home fire hardening is going to be part of this same statute. Okay, so when is the best time, Rocky? When is the best time for the seller to complete the home fire hardening advisory? At the listing appointment. Okay, folks, listen, we got to be professional about what we do. When you take a listing, you need to go in there and get all of those disclosures done at the time of the listing. Okay, you need to protect yourself, you need to protect your broker, but more importantly, you need to protect your seller. You have a fiduciary duty to do that. Okay, so as I said, along with the other statutory disclosures. And what are they? We've got a lot, right? You're not even going to believe I've got pages of statutory disclosures. My agency disclosure, we have attached that to all of your offers, all of your listings. It is the very first thing your client ever signs before you have a substantive conversation with your client, because they're not a client until you've signed an agreement with them. And the agency disclosure is not an agreement. Agency disclosure is just that. It is a disclosure. But if I'm on the listing appointment, I'm going to get them to sign an employment agreement, which is what my listing agreement is, and I must disclose the concept of agency prior to committing conduct that constitutes agency. Okay, and then when I put in here confirmation, that's because confirmation, we don't know at the time of our listing whether or not we're going to be single agents or dual agents, and so the confirmation will come later on when the offer is written. My transfer disclosure statement, my favorite document, next to the RPA, next to the residential purchase agreement, the transfer disclosure statement gives me lots of job security. Okay, meth lab cleanup order, lead-based paint pamphlet and form, Melrose 1915 Bond Act assessments, How about some more? Advisability of title insurance, airport in the vicinity. Some of these things you don't even think about. Some of these things, but these are all required. These are all statutory requirements on the seller for making those disclosures. And you, as the agent, are responsible to let them know that there are disclosures that they need to make in a real estate transaction. Now, the good news is that most of your natural hazard disclosure companies are going to cover a lot of these things for you, but you need to make sure that you read these reports to confirm whether or not all of the ones that you need to have are being done. Airport in the vicinity, probably going to show up in your natural hazard disclosure, but everybody's reports are different. Okay, but my carbon monoxide detector compliance, okay, health and safety code, all right, that's required. That's not going to be in there. That is, by the way, in my TDS. Common interest development. Remember, these are things that the buyer has rescission rights associated with. You must disclose, the seller must disclose whether or not the property is located in a common interest development. Okay. Death on the property in the last 3 years. That's Civil Code 1710. Okay. I didn't put the civil codes next to this because the important part is not the code and you being able to quote it, but the important part is, are you aware that there is a requirement? So, I always ask the question, somebody says to me, well, so-and-so died in bedroom number 2 last year. And I always say, did you kill them? Because that's always my first question, because I want to make sure I'm not involved in a crime. But the bottom line is, we need to disclose the death on the property. Okay, all right. It's not a class on that. It's not a class on all these disclosures. But I wanted you to be aware that there are a lot of very important disclosures, most of which can be handled at the time of the listing appointment. And again, I always save the listing agreement for last. Okay, because my listing appointment really needs to be about the disclosures that the seller does. And so if you've seen my presentation on how to create the winning listing presentation, first thing I ever have the seller do is let's just sit down and fill out all these disclosures. I mean, even if they weren't really convinced that they were going to be working with me, have you ever gone out to buy a car and the salesperson just kind of took you right into a presumptive close and started talking to you about, all the things you can do with the car? It's the same kind of thing here. Now, I'm going to talk to the seller about those disclosures that are going to be required, and it's probably a conversation that they've never had before, even if they've been a seller before. And we just throw forms at them during the transaction, and we try to minimize our interaction with the client. No, I want to sit down with them. I want to go over what is FERPTA, right? And, I want to go over why is that important? You're moving out of the country with the money. The last check's going to go overseas. You know what? You're going to be subject to California and federal FERPTA. Okay, so here's the form that says what I can't tell you because I can't give you tax or legal advice, but here's the form that talks about that. Okay. My flood disaster insurance requirements, it's a requirement. How do you know that there's insurance required if you don't know if it's even in a flood zone? All right, but this is from the list of statutory disclosures in California. Gas and hazardous liquid transmission pipeline. This is another example of a disclosure that was legislated to us that we have to make, even though on your SDAR risk management committee, which is meeting in half an hour, in your risk management committee, we discussed the fact that we did not think it was a good idea to tell everybody where those transmission lines were. Why? Because we might be encouraging domestic terrorist activities. And so, these are serious issues. I do know that today we're going to be talking about the RPA, so the new one that's coming out in December, which I've already been doing classes on, but the final version is going to be released in the next couple of weeks at our CAR meetings hypothetically in Sacramento. I was talking to Linda today about that. We all missed out on last year. We didn't have a convention center. They had leveled the convention center in Sacramento, and so we were all worried about how we're going to handle 1,200 real estate agents or realtors in an area. And then we ended up going completely virtual. So Homeowner's Guide to Earthquake Safety, if built pre-1960. There's my transmission lines again. That's how important it is. We talk about it twice, so it must be important. Material facts, Megan's Law disclosure. These are all things, military ordinance. Okay, so it's not a military rule. There's no I in there. That means this is stuff that goes boom. Okay, and so we still have instances of people being injured by unexploded ordnance. So mining operations, mold, that's a word you're not allowed to use. You don't have the credentials for it probably. Pest control inspection report, and I only threw that in there because the law requires it if a report was done. So if you're aware of a report, then you have an obligation to give it over to the buyer. You can't just put it away and say, I don't have to give that to you. If there was one done, then you have to give it to the buyer. There's no requirement by law to have one, but you have to give one if you have it. Private transfer fees, environmental hazards booklets, by the way, in your rentals as well, your leases, smoke detectors, supplemental property taxes, water conserving fixture compliance, water heater, bracing safety, window security bars, and my natural hazard disclosure statement. And again, 2 earthquake, 2 fire, 2 flood. Okay, so today we're talking about the 2 fire ones. All right. Okay. Oh, I made a little thing. Watch this. Okay, so watch now. Watch fire. See fire. Okay, I learned a little thing on how to do a PowerPoint, so you gave emphasis to something. Anyway, okay. So we're going to talk about paragraphs 3 and 4. Seller may make the disclosure even if not required by law if they're not sure. It's okay. It doesn't hurt. Go ahead and do the disclosure, or does common sense dictate that you should make that disclosure? So, so let's take a look at what those things look like. So, if I have a final report, oops, did I jump ahead? I did. I jumped ahead. I'm sorry. Where'd it go? Did I? Oh no, it's not even there. Okay, I thought I had it in there. Oh yes, we have a final report. Back where was I? Yes, make the disclosure even if you are not sure if it's required. Seller makes the disclosures by contract within 7 days of acceptance. So you remember all those things. Seller has to give the buyer all this stuff within 7 days. The buyer has 17 days to absorb that information. And again, if you delay getting it to the buyer, you may be triggering their right to rescind the contract. So you want to get that to them pretty quickly in the transaction. Okay, standard rights of rescission apply. We already talked about this. Contract, the buyer can make the contract go away like it never existed. And guess what? When we make the mistake as the seller's agent, we may be giving the buyer an opportunity to renegotiate an otherwise bad deal for them. And so that's going to end up costing us money. So we want to make sure we don't, we want to make sure we're professional about what we do, get all of those disclosures signed at the time of the listing, get those all over to the buyer with the counter offer. Anything you send after the buyer commits to the contract is going to trigger rescission rights, time for them to get out. If you give it to them before they commit to the contract, the courts have held that, you know what, you bought the place knowing it. Here's the disclosures. You knew that what you were buying. Okay. I do get this question. I had this question at a pitch session yesterday where, people are doing contingent free offers. And I thought it was an interesting concept. And I said, what you're really asking me is whether or not the buyer can get out of a real estate transaction, if they write a contingent free offer. And remember, the mistake that we make is, as the seller's agent, that we get them to write the contingent free offer. And I personally don't believe in contingent free offers, but we get them to write the contingent free offer. Now they feel trapped into something, and then we send them over the disclosures. Now, if you send them over the disclosures again, now you've given them a way out of the deal if you sent it over after that contract was committed to. So even though they have agreed by contract to have a contingent free offer, you may, it's right in your purchase agreement, it says you may not waive a statutory right or lead-based paint disclosure. And lead-based paint, by the way, is a regulation. It's not a law. It's an EPA regulation, and it's a very powerful one. So the buyer has ways to get out of that deal. And imagine the buyer now has shaken off all of the other buyers because you probably went multiple offer. And again, I'm a practitioner like you. Okay, so your buyer who's feeling trapped in a transaction, but now they've gotten rid of all the other buyers. So we've shaken the tree. They're the last one standing, and now you give them the disclosures and give them a way out of the deal. And they're probably going to look at that, look at their ability to be able to rescind that contract based on that. Okay. Any questions about any of that so far? It can be pretty ugly. It says it right in your purchase agreement. You may not waive a statutory right. Okay, all right. That being said, here is my readyforwildfire.org. I was very proud of this slide. Home fire hardening notice now. So this is paragraph number 2, the first part. So they had right in there in the language that was in, let me see, where was it? Right down here at the bottom, readyforwildfire.org. Okay, we had it right in there. And this is the website. It's really kind of a cool website. You can go in here and you can find out all kinds of really neat stuff, and whether or not, for example, you have your defensible position. So that's the website, readyforwildfire.org. I would recommend that your client go to it. It's a little easier to read it this way with the R and the F and the W, I think, than it is the way we've done it in the form, where it's all in uppercase and it's kind of hard to make out what those words are. Okay. All right. Okay, that being said, going to my next slide, we are now going to paragraph 2.2, and I want to show you what paragraph number 2.2 says. So this is 2.2. Now, again, remember the default says that the seller is that there's nothing wrong with this place unless the seller checks the box. If the seller checks single pane or non-tempered glass windows, then it says this seller is aware the following features may make the home vulnerable to these things. Okay, so these are the things that could make this home susceptible to catching on fire. So the default, if the seller doesn't check anything at all, then none of this applies. Okay, so again, affirmative. If the seller doesn't know, they can't know what they don't know. And I had a trial, in fact, the last court case I was in court in front of the judge, and I said to the judge, I said, the seller can only disclose what they know. I mean, they can't disclose what they don't know. They either know it or they don't. If they don't know it, they can't disclose it. And so we were able to prove that, in fact, the seller wasn't aware, didn't have any idea. And then, of course, my final report, and that's going to be, so knew or should have known was my standard of care there. My final inspection report, which is paragraph 2.3, seller has obtained a final inspection report if they have one. They don't necessarily have one, but if they do have one, it includes the defensible space compliance, and that is my government code 51182. So, boy, that's okay. We're moving right along. Any questions so far on anything we've talked about? Because I'm going to go ahead and move. We're going to move along here. If you have a report, the copy is attached, or you can refer the buyer to the location where it is. So again, the assumption is there is no final inspection report, but if you check it, that means the seller has one, and that includes this language in here. Okay, questions about any of that? Now we're going to get down to my signature line. So let's talk about my signature lines, and this is why this is pretty important. So notice it says right in the signature line, it says seller has provided the answers on this form. So again, and I'm kind of smiling here because it's like, please do not fill out the form for the seller, okay? And the seller, by signing it, says that they have provided the answers. And again, they're going to say, I don't know what these things are. But this is, now that you know more about this form than probably anybody knows, because nobody's paying attention to it, this is really, really important. Make yourself a hero. You sit down with the seller, go over the form with them. Again, remember, you have a real estate license that allows you to explain the standard forms, not necessarily a form that somebody else has provided. So the seller needs to be aware, Mr. and Mrs. Seller, here you filled out this form. Is this, it says right here, you have provided the answers on the form. And by the way, I have not provided those answers. You have, okay? Again, Rocky, I keep coming back to what you said about ordering NHD as soon as you take the listing, and I'm with you 100%. Get that NHD in front of you right away. Get that in front of the seller. Now you know how to fill out the form, okay? What about living next to the San Diego River, Mission Valley, which I believe is a flood zone? It absolutely is. Daniel, you make a good point. The I-8 essentially is the San Diego River, isn't it? And so should the seller know, or should the seller have known about it, about living near that area? I don't know what that has to do with fire necessarily, but if your natural hazard will pull out that area is in a flood zone. Okay, remember, two earthquake, 2 fire, 2 flood. So thank you, Daniel. Good question. Okay, seller has provided the information on the form. Seller represents the seller has provided that, and that information is true and correct to the best of the seller's knowledge. Okay, so again, to the best of their knowledge, they can only know what they know. Okay, and then they acknowledge that they have received a receipt of that home fire hardening disclosure and advisory. Okay, pull back up my thing here. True and correct to the best of their knowledge. Okay, they filled it out, and they filled it out truthfully as best as they could. Okay, and again, in my scenario I gave you earlier, where we were doing a transaction, and the buyer's agent came back and say, "Wait a minute, seller said that it wasn't in the zone." And yet it shows right on the NHT that it was in the zone. They asked us to amend the form, to change the form and send it, which of course is risky, because then that would have triggered the rescission right. Remember, your contract also says that if the buyer is made aware of something that's a discrepancy, but that the seller had given different information, and they received that information as a result of a report or something else that they learned during the transaction, it does not necessarily trigger that 1102 rescission right. Okay, so the buyer discovered it on their own, so now they can't move forward and say that the seller made a misdisclosure or a missed disclosure, and so the buyer would not necessarily have rescission rights attached to that knowledge that they got when they got the natural hazard disclosure report. Okay, that's what that says. So the seller is saying, to the best of my knowledge, this is where we are. And then the buyer acknowledges receipt, and that's always my favorite part, right? So, where is it? The buyer says, I didn't get it. And then here it says, buyer acknowledges receipt of this home fire hardening disclosure and advisory. And one of the things that I did not do, and I should have pointed out, was that on the form itself, folks, you can see the form behind me. On the form itself, I want you to see this. So when I'm looking at this form, this is the original form. I'm scrolling down here. We took this form apart, okay? Do you see anywhere in here where the agent signed? All right, so only the parties sign this form. And when we create these forms like this, when we create them without having the agent's signatures, we do that for a reason, okay? Because we're not parties to this contract. We're not parties to the agreement between the parties for the purchase of the home. We are there essentially as facilitators. In fact, in some states, they call their real estate agents facilitators, not agents. So notice that there's no place in here for you to sign. And so I don't think you need to go out of your way to do that. Your obligation by law is merely to provide the form to the seller for filling out, and then relaying it to the buyer. And again, remember, Civil Code 1102, which is my TDS, attaches to this form, and the same rescission rights are associated with it. So do not miss out on this form when you are having your seller sign disclosures, okay? All right, so buyer acknowledges receipt. Now they got it. Can't say they didn't see it. Are there any questions about any of that? I want to go over any questions really quick in case anybody has anything. Hey, Claudia, Don, Jeff. Wow, got a lot of important people here today. Very important people. You're all very important. Melody is here. Okay, I feel like I'm in a romper room again. I can see everybody through my little, mirror that goes away. Anyway, any questions about any of that? Anybody have anything for me that you have critically important? And again, I want to thank Rocky, because she brought a really good point home, which she read ahead, I guess, because she knew where I was going to go with this, and that is, you need to get all of these disclosures signed and all these disclosures filled out at the listing appointment. Thank you all for being here. I wish you the very best, and I look forward to seeing you again at a later time. Thank you all. Take care.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.